Welcome to another episode of Seeds of Tomorrow. Today, our two remote guests are Ignacio Giacchi from the Anti-Infringement Bureau and Philippe de Jong, partner at Altius, a Belgian law firm. On studio, we have Francesco Mattina, our president. Good morning, Francesco.
Good morning.
Good morning, Philippe.
Good morning.
And good morning, Ignacio.
Morning, everybody.
For our listeners, Ignacio, what the Anti-Infringement Bureau does?
Okay, the Anti-Infringement Bureau is basically an international non-profit association based in Brussels. And as an association, it has been created by the main vegetable breeding companies to fight illegal seed practices. Mm-hmm. This covers a lot of things. I don't know if you want me to elaborate or just give you a quick summary.
Please do.
Okay. Say, for example, one of our members has a suspicion that a certain company in a certain country is reproducing illegally one of the plant varieties. At that point, they would contact the AIB and they would ask us to do some investigations. Mm-hmm. Ideally, what we should be able to do is get all the facts right to make a determination. Is there an infringement or not? If there is an infringement, mm-hmm. do we have a legal basis to take action, for example? Does the breeding company have a plant variety right in place? And if so, we should be able to gather enough elements so that we can bring the case to the concerned authority and ask them to take some kind of action depending on the circumstances. Usually that would mean going to, for example, a grower's premises or a nursery's premises and collecting samples. Mm-hmm. That's basically the main thing we're called to do.
Okay, thank you. Very clear. And Philippe, what do you do at Altius? You are a partner there?
Yes, I can be brief about that. Yeah, I'm a partner at Altius. Altius is based in Brussels, so we're very close to the European institutions. We do a lot of things, but my job in the firm is heading the Agri-Food Law Practice Group. And in that practice group, there's a lot of focus also on plant variety rights. We do a lot of enforcement cases, both in Belgium and together with partners in other countries, also coordinating some of the litigation in these other countries. And perhaps I should mention that I've worked in the past as a consultant for the Community Plant Variety Rights Office a long time ago when I was still young. And we set up at that time a database with case law, which I believe up until today is still very much present and prominent on the CPVO website. So
your legacy.
I'm not saying it was my legacy only. It was with the then president and then head of the legal council. Head of the legal unit of the CPVO. But it still exists, so I'm happy to see that those efforts paid off well.
Yes, indeed, I can confirm. And I'm a supporter of
Thank you.
Of this tool.
Well, thank you for this very clear introduction of what your work is. And could you explain the importance of enforcing plant variety rights in the context of agricultural development? How do you see it?
Okay, it's interesting. Again, as an association, we have a table where you're going to find different companies with different views on how to go about protection of plant variety rights and also enforcement of these rights. Mm-hmm. And it's a very tricky area because, like no other industry, the seed industry is unique in that oftentimes the infringer is one of the customers of your members. And obviously that creates some kind of friction, some kind of conflict of interest, which is why the people who envisaged creating the AIB thought of the AIB as a separate entity who would not see a conflict of interest and basically decide not to take action. Quite the opposite. Whenever mm-hmm. we become aware of an infringement, we know we can go ahead and take action. But many companies, they have a policy to protect and not so much to enforce, okay? They think, okay, by protecting, they're doing their part. But when it comes to taking action, I don't know, there could be some backfire, basically, because you take action in the market and the word gets out and everybody knows that you're taking action against a grower or a plant raiser or a distributor. And that's generally not good for business. So it is important to enforce your rights. So this is why we have the AIB. It's basically an umbrella that provides some kind of protection for its members. But why is it really important to enforce plant variety rights? Okay, companies within the AIB, we know that they invest between 20 to 25% of their revenue in research and development. We know that for developing a new vegetable variety, you have to spend between 5 to 15 years, which is one single variety. So if you're spending all that much money and all that time to bring to the market a new product and someone goes around and basically reproduce it without authorization, that causes great damage. So it's important to protect your variety, but it's important to enforce your right so that you can basically continue recuperating your investment and ideally channeling those investments into new varieties, especially in the context of climate change. You know, with all the abiotic and biotic stresses, it's becoming more and more difficult to grow produce in the fields.
I see that you just won. Well, the Court of Appeal of Catania just ratified 15,000 euros fine to a grower, an abusive grower, and their verdict fell on December 2023, and you initiated this.
Correct.
This case. Correct.
It's a very interesting case. To some extent, it's also a landmark case. I have to clarify that we started this case back in 2015.
Wow.
So, I mean, do the calculation. That's one of the problems we usually encounter when seeking to enforce plant variety rights. The case you're mentioning, it's a criminal case. It's not a civil case. A civil case, I imagine it would have taken not this long, but it's still a very important achievement because after how many years? Probably 9 years, we finally got a conviction or confirmation from the Court of Appeal against this grower. It's a case of vegetative propagation of a tomato plant. So obviously we're very happy with the outcome, but there is still a possibility that the infringer will file another recourse with the Court of Cassation. So we're still waiting.
So we are on the second step out of the third step that Italian law allows.
Yeah, we've succeeded at first and second instances, and now we're looking at the possibility of taking things to the third instance and final. Let's hope.
Well, we just dive into Italian laws, but Philippe, how do you see the current EU policies around infringement and enforcement of plant variety rights? Are we on the same tune all around Europe, or do you see discrepancies, needs for further refinement?
Well, when you mention policies, I think the first question would be what policy? I think in terms of plant variety rights law, there was a study that the European Commission conducted already back in, 2011, 2013, which evaluated the value of the current system because, let's face it, the current basic regulation, as we call it, is already fairly old. And I remember that despite the fact that everybody was pretty happy with the system as it stands, there were also a number of shortcomings that were identified or room for improvement that was identified. However, ever since, to my knowledge, but perhaps that's a matter where Francesco is better to give input on, I haven't seen much development in terms of policy. I don't think the Commission actually followed up on that, at least not externally or expressly on that study, and I understand certain initiatives or ideas are ongoing to improve the regulation and the system. So when you ask me whether the current policy is the right one, I'm not sure exactly what the Commission's policy on this point is. There is one recent policy initiative that indirectly touches upon plant variety rights, despite the fact that it does not deal with it directly, but which may have a huge impact on the plant variety rights system and the CPVO, which is the compromise amendment, the compromise proposal that was made by the European Parliament to ban essentially all patents on so-called NGT plants, so plants obtained from new genomic techniques. The Council is currently trying to find a solution, but also there, my understanding is it's not so easy to come up with one. But it's important. Why? Because the European Parliament has indicated that according to it, these NGT plants, they should not be protected by patents, but they should all be simply protected by plant variety rights. The question, of course, is whether the plant variety rights system is adapted to welcome all these NGT plants. Quite frankly, I also don't know. Perhaps there's another reason to ask for additional funding, but whether the CPVO is equipped to deal with all this, because it's very well to suggest that patents are not allowed, but obviously plant variety rights don't deal with traits as such. They don't deal with genetics. They deal with the whole thing, the variety. And it will be very interesting to see whether technical questionnaires, the phenotypical examinations can be adapted to host these new NGT plants. And in addition to that, what qualification will be given to them. We all know the new UPOF explanatory notes, which essentially suggests that every NGT derived variety is an essentially derived variety. And I know there's opponents, there's people in favor, but the bottom line is that if that is the case, the scope of protection of these new NGT-derived varieties will in any event be limited, because they can never be initial varieties under the EDV concept. So there's a lot of things in terms of policy to think about in that regard, because if this becomes a reality, and I'm not sure whether it will, but a lot of people are pushing for it, then that would also mean, I think, that there's a lot of, there's more work for the CPVO to be done, and arguably to create a system that is really, that can be really beneficial for this new technology, and hopefully we will see that apply in practice in the future.
Yes, a lot of elements on the table. The first thing that came to my mind listening to Philippe on these so different topics and building up on a rather long period in this practice, I would say that the first challenge still today when we speak of EU policies, and I could give you a number of examples, is still the fact that plant variety rights are not treated as other IP rights. And often, still today, in discourse, in conversations at policy level in the EU, they are not equal as patents, trademarks, and copyrights. You may have seen recently this toolkit for enforcement of IP rights, and plant variety rights are not mentioned among the IP rights in the definition of IP. So you find trademarks, patent, copyrights, etc., but you don't find PVR. And this is openly in contradiction with the so-called enforcement directive, the directive number 48 of 2000 or 2002, if I'm not wrong, where it is clearly stated that the measures of the enforcement directive apply to plant variety right as well. And this covers also the regulation on customs monitoring for infringement of IP rights. So I think we have done a lot of progress, but still today, plant variety rights are not acknowledged as an IP right like the others, the big one, because it's treated as a separate right, is kept under different responsibilities in the Commission organization, and this may lead to a misconception that this is not an IP right like patents and trademarks. Now, what Philippe is saying, that the European Parliament position on the issues of patentability of NGT's plans reflect a clear concern of politics with the patentability of these innovations, because we are talking of innovations here, inventions. So we're not going to enter into the discussion whether it is correct or not. I may have my personal opinions. However, I think that this is calling back to us, brings back to the table a discussion on the interface between patents and plant variety rights. And even if the basic regulation is old, because it's an old regulation of 94, I think it is still actual and very present, the fact that it acknowledges the necessity of balancing the other IP right system with the PVR system. And this is something which is stated in the basic regulation and which I would not advise to touch and to change. So the fact that we have different IP systems that fulfill different purposes and have different objects of the protection, clearly, patents versus PVR. It's undeniable that the object of the protection is different, is not new to intellectual property. We face other domains where we have to deal with the interface between different rights. I don't know. I think of industrial design and three-dimensional trademarks, for example, and unfair competition, etc. So this is something which is not new to IP. It's part of the IP discourse on va dire, no? We can say. And we have to find the right balance position. I'm not sure that banning an IP right is the right approach for the future of this innovation. I'm not sure. It's all to be debated and discussed. However, this is also bringing back the fact that the plant variety right system is an IP right system. It has to be protected and incentivized as such, and it is not a minor IP right system when compared to patents or trademarks. And I'm saying this also because maybe you, Ignacio and Philippe, you have also more hand-on feedback. There is a trend, or what it looks like a trend, that breeding companies are protecting more and more trademarks and less plant variety rights. And they are enforcing more trademarks than plant variety rights. And they are doing more license agreements and any other kind of contracts based only on trademarks and not on plant variety rights. I'm rather critical with this approach because clearly you protect different things with a trademark and you don't protect the variety with a trademark, right?
Yeah. I'm not sure whether that was a question to us, but if I may, you're right that obviously this happens, and well, obviously every case is different and every client is different. But from what I see, client do use the plant variety right system when they can, but sometimes indeed you end up in a situation where either you cannot get a plant variety right, or when your plant variety right has lapsed. And then, as you've suggested yourself before, there is nothing wrong in combining the two systems. And clearly, every plant breeder that decides to enforce a trademark instead of a plant variety right must be conscious of the fact that, as you said, the subject matter of protection is completely different. If you enforce trademark rights, then all you can do is protect the sign in question. You cannot prevent third parties from reproducing, multiplying the underlying variety. And so indeed, that's a weakness, but I'm assuming that everybody should be aware of these choices when they choose for trademark protection. And so, but my experience is that people try to have both, not just one of them.
Ignacio, what's your take?
My take on that, we're about to launch an internal survey to establish what are the protection ratios amongst the breeders. And basically, we're going to have a column for crops, another column for listed varieties, one column for plant variety, protected varieties, one for patents, and a new one for trademarks as well. And the idea is that we're going to do this exercise every 3 years, so that we can identify whether there are any changes. Maybe we'll see that, in fact, regardless of what the circumstances are now, maybe 3 years from now, the protection ratio for trademarks goes up and the one for PVP goes down. But it's interesting because the discussion about plant variety denomination, for example, is a topic for the breeders, the growers, the plant raisers, but not so much for the consumers. When you go to a supermarket and you buy a package of tomatoes or some kind of packaged lettuce, you don't go by the variety denomination. Oftentimes you go by what the company that basically cut the material and put it in a bag. But if you introduce the concept of trademarks, then you make it a topic for the consumer as well, because in the future they want this certain product and not a different one. And that's why I think some breeders are trying to use trademarks as well, not just as a complementary or supplementary protection way, but also to establish a more direct communication with the consumers, so that they can become a part of the fight in the future.
And this brings me to the discussion we had some years ago on the opportunity to introduce a symbol that identify when a variety is protected by plant breeders' rights. In copyright, you have the symbol. In trademark, you have the R. In patent, you have patent or patent pending, something like that. And I think we should reflect on the necessity of introducing this kind of symbol that identify clearly also to the consumer that there is a protection behind, and not only a trademark.
Indeed, this is also an awareness issue, raising awareness among the public, doing the right or the good choice, or the choice that you wish to do in purchasing a protected variety. But this brings me also to another question. I know that both of you are very active in trying to raise awareness.
Yes.
Also in your fields of expertise, which is, of course, in the importance of plant variety rights, but also on the infringement of those. Do you care to?
If I may,
Sure.
For us, it's basically an obligation to raise awareness and a need as well. Why? Because when one of our members has an issue and we have to bring that matter to the authority's attention, we need to convince the authority to help us. And without doing without laying the foundations before we bring the case, most likely we're not going to get anything out from that conversation. So, for example, within the AIB, we have decided that we have two target audiences that we should prioritize. One is, of course, enforcement authorities, and the other one is sales staff of our members, because they're basically the ones basically communicating on a regular basis with growers, plant raisers, distributors, so they know exactly what's going on in the fields. And we have to spend time educating this audience so that whenever they find there is an infringement or they have a suspicion of infringement, they can bring it to us. And with authorities, it's the same thing. We want them to know what are the basics of plant variety rights, how much money companies are investing for developing these new varieties, how long it takes, so that they can appreciate the technicalities. This is an extremely technical IP type, right? It's not like trademarks, which is much more straightforward. It's not like, even patents can be very, very complex. But I dare to say that patents have gained a better standing than plant variety rights in the community of enforcers. They understand the topic much more than they understand plant variety rights. That's why it's important to spend time educating and training authorities, providing them with practical tools so that they can help us.
Philippe, you want to say something?
Yeah, obviously my role as a private practice lawyer is different. My only task is to represent the interests of the clients that I have. But I do try to go beyond that and indeed to raise awareness. For example, every year we host our agri-food law seminar, which in the past was called Plant Variety Rights Seminar, but we broadened it up. And so that is, I think, an important initiative. We've had the honor of welcoming people from the CPVO as speakers in attendance at our seminar. So I think that is definitely a tool that we use to create awareness beyond, obviously, while many of our clients attend, there are also non-clients and people from the government and so forth, and enforcement authorities that attend. In addition to that, we organize, it's not just for plant variety rights, but horizontally across the entire IP spectrum, training for customs authorities. We're very actively involved in that. This is particularly for the Belgian customs authorities, but there are a number of our plant variety rights clients that are there to explain to the customs authorities how plant variety rights work, how their products can be recognized by the customs authorities and so forth. And in addition to that, I was recently invited by the CPVO and the EU IPO during a event that they organized in Alicante, which I found a truly extremely useful initiative, which brought customs authorities and industry representatives together precisely to try and make customs authorities even more aware of the specific intricacies of plant variety rights and how to recognize allegedly infringing plant material at the EU borders. And so also there I was present. So that goes beyond my purely client attorney relationships, and I like doing that because I'm very convinced of the importance of the plant variety rights system for the future. These are just a number of examples.
Yeah, and I think that our mission to raise awareness also, and particularly with the judiciaries, with the courts, with public prosecutors and the custom officials, it's one of the biggest challenge, but also the biggest opportunity that we can make more investment upon. So it's an ongoing exercise that has to continue, and I believe we have to improve targeted actions with this kind of audience. From our perspective, from CPVO perspective, even if it is undeniable that it's the responsibility of the title holders to enforce the rights, what we can do to support title holders is to make more efforts to educate enforcement authorities, so judges, customs, and so the prosecutors as well, because this is also a criminal offense. It is not only a civil infringement case, it's a criminal offense in the national PVR systems. Although there is no harmonization at European level in criminal law, it's the choice of the title holder for each case to choose which route to go, either criminal or civil or both, or to activate other administrative procedures. That's also possible at level of inspections services in the member state authorities. So there is a full range of possibilities to fight infringement, in fact. So I believe we have to do more in raising awareness and education for the judges and the prosecutors.
Yeah, if I can just add to that in terms of, I think it goes beyond merely raising awareness. I think what I would personally find useful from a practical experience is that there would be more institutionalized interaction between courts and the CPVO. We've discussed before that plant variety rights are, despite the fact that they're an intellectual property right, they are different from other intellectual property rights in the sense that they're the characteristics. There is no paper definition of what a variety is. We have the variety description, which, as you know, contains relative values, and you can see that courts and, well, pretty much everyone is sometimes struggling with that notion. And so I think it would be very useful to have an interaction, an institutionalized interaction between the CPVO and courts as it exists, for example, under the patent system. The European Patent Convention has a provision which allows the national courts to ask for technical opinions to the European Patent Office in cases of validity. And precisely because national courts are obliged to consider EU plant variety rights as being valid in the course of national enforcement proceedings, but also because a lot of plant variety rights are for varieties that are, well, distinct, but still closely resemble other varieties from which they were declared distinct before. I think it would be very useful, rather than obliging parties to go about and finding their own ways of trying to prove distinctness, which usually does not lead to anything, is that a court could say, well, we basically assign the CPVO with this task in the context of concrete enforcement proceedings, so that the right examination office who has the experience in the specific crop can be involved and can offer useful assistance in the outcome of a concrete case. I think that would be useful.
Philippe was mentioning that all around Europe there are laws that are different and interpretation that can differ. And Ignacio, you have all Europe to monitor, let's say so. Do you see any technological advancement that is helping you in identifying and preventing IP infringements? I'm thinking drones, I'm thinking AI, which is all over the news these days. Are you using them? Are you planning to use them? Do you see a merit in using them?
I mean, there's been ample discussion about the use of drones. I mean, what are we talking about? Using a drone so that we can explore a certain field and take photos of a certain plant. And based on the photograph we obtain, we could make an expert could make a determination whether that is our protected material or a different material. I mean,
is the technology there?
In theory, that would be possible, but to tell you the truth, when I try to convince people, especially because we have within our internal teams, we have investigators who are big supporters of using drone technology. And then you have the agronomists who have the technical knowledge, and they would be reluctant. I mean, as far as vegetable varieties go, they're not comfortable that would be enough to make a determination. So eventually what you always need to do is collect samples and do DNA tests. So basically a photograph on its own would not be enough to make a determination. but I mean, I don't know if I may call them, technological tools, but basically, we use when, for example, you have certain people suspecting that a grower is reproducing a variety illegally, they are going to share with you the GPS coordinates. And nowadays, with a smartphone, you can do that very easily, right? So I don't feel bold enough to say that would be, us using technology. But we do use a lot of databases to obtain data, open source, and also we use our own database to process infringer data and to have statistics. And we are calling that the AIB Watchtower, which is basically an initiative to have global statistics for illicit practices. I'm not sure that was your question, really, was it?
No, I'm asking you this question because we recently visited fields in the southern part of Italy, and they are trying to use imaginary to detect if a variety is the same of another that is being grown or not. And I know that there is a lot of discussion about the use of drones and massive quantity of data that are going to be used with the help of AI to detect if I thought this question as to save your time in a nutshell, because if you are going everywhere and you suspect that there are a lot of fields, then it might be useful for you to use this technology in order to save time and to discard everything that is not pertaining to what you're looking for.
Yeah, basically you're talking about using drone technology, for example, for narrowing down the sampling pool. And that makes sense. It's basically table grade companies that are using that technology. But it's different for them because we basically focus on seed material, right? For what we're after, drone technology would not really be helpful enough. But I understand why it would be helpful for other crops and asexually reproduced plants, for example.
Yes.
Yeah, I think it's something that can be part of the toolbox, but at the moment, not more than that. It's very much comparable to the use of molecular techniques in the context of managing reference collections. In a way, it's, as you say, it's to discard those varieties or those crops that you don't need to focus on.
Okay, thank you. We are nearly towards the end of the time that we have together. My question for both of you: what is the future? What are the future developments that you foresee in the field of PVR enforcement?
The we foresee or the we hope?
Both.
We'd see. Because basically, if I may go first, basically within the European arena, I think there is a complete lack of uniformity in the criteria for for determining the necessary number of markers for determining whether a variety is infringing or not.
Yeah.
And this is going on everywhere in the world. And for some laboratories that would say if it's letters, 48 markers would be enough, then you would have official laboratories saying we basically based our results on 20-something markers, and that's enough for us for identity purposes. But then the judges have a different understanding because the judges are thinking they want to see a grow-out test done, and they don't really grasp how the US and genetic marking could complement each other.
Yeah.
And that's an area where we always struggle. And that means proceedings going on for years, and then eventually if it's a criminal case, a criminal action being declared, prescribed. So it's a big issue.
Yeah, I tend to concur with that. That was going to be one of the points that I wanted to mention as well. I'm not sure how it can be solved and whether it should be solved at the level of legislation, because in the end, it does remain a matter of enforcement on a case-by-case basis. But indeed, the uncertainty around the use of technological tools such as markers And then depending on what tool you use, there will be more criticism. There have been cases which have blatantly gone against the use of AFLP, for example, because the technology uses dominant markers and overestimate genetic similarity. So that is obviously very detrimental to enforcement cases, and that results in these technologies currently only being used in either matters that where you do not have to establish infringement, but more proceedings relating to gathering evidence or PIs, so preliminary injunction proceedings, where the threshold is lower than in a normal case on the merits, because in proceedings on the merits, to my knowledge, indeed, as Ignacio said, in the end, courts will always look at phenotypical similarity or non-distinctness, essentially, because that is, according to the law, the only criterion that applies. And you can use technological tools to support those findings. But given the fact that the system allows varieties to be granted, whereas they are not so much apart, you may have a high degree of genetic similarity. You may even have a high degree of phenotypic similarity, but still in the specific crop not end up with proof of infringement. And so in addition to that, I think that is a matter of enforcement, but also at the level of protection. And it ties in with enforcement. What I would like to see very much is some sort of DNA fingerprint being attached to the plant variety right certificate, because, and that ties in with what I said before, it's very difficult in practice to enforce a plant variety right merely on the basis of the variety description, whose value is very obscure. So I think I know it's not possible for all characteristics, but particularly also with NGT technology becoming more and more dominant, I would think that in the future, a DNA fingerprint for the most essential characteristics could be envisaged if it's technologically possible, but it should at least be discussed whether that is an option. And I know in the past, the CPVO has suggested that itself. I remember at some event that I attended many, many years ago, I think it was at the farewell of Bart Kiewit, so that's a long time ago. The suggestion was already made to attach a DNA fingerprint to the variety certificate, and I still think that that would be useful to help enforcement because it's necessary.
And this concludes our episode today. A big thank you to our guests and to our listeners. Keep following us on the socials to stay updated on the latest episodes. This is Alessio De Laurentiis signing off. The music you're listening to is from Giacchi, a Lombardi and Amoruso production.